versus CWS Marketing Group, Inc.
Hear from the appellant when you're ready.
Good morning, Your Honors.
Good morning.
I'd like to reserve 3 minutes for rebuttal, please.
That'll be fine.
Your Honor, please. This matter was tried in Hamlin County Chancery Court for the Honor. Hamlin County.
No, introduce yourself, please.
Oh, I'm sorry.
That's okay.
Attorney Troy Boland for the appellant.
Okay.
CWS Marketing. I apologize, Judge. Your Honors, this case was tried in the Hamlin County Chancery Court before Chancellor Jenkins before a jury. Prior to this jury trial, there were 2 motions that were filed that were dispositive. One was a motion to dismiss. One was also a motion for summary judgment. We argued both of those motions. The court denied the motion for summary judgment. We proceeded to trial. What's this case about? Paul Lebel purchased a piece of property that the IRS had seized from someone who was charged in federal court with drug trafficking offenses. CWS Marketing is the marketing agency for the Department of Treasury Internal Revenue Services. They advertise this property on Department of Treasury and IRS letterhead. They advertise it as being available and as having 35.5 plus or minus acres. That's, I think, demonstrated in the trial transcript as well as Exhibit 11. The marketing materials directed individuals who were interested to contact CWS Marketing and or the Department of Treasury to inquire about this particular piece of property. Paul Lebel was someone that was interested in this piece of property. Mr. Lebel had been in the, and still is, been in the commercial real estate industry in Hamlin County, Tennessee for some 20 plus years. Mr. Lebel, seeing the property, this is in the trial transcript, not telling the court that anything that does not exist. Mr. Lebel knew that there were certain days in which he could go and view this property. The IRS rules and the Department of Treasury rules are very strict, and you can't be going and viewing property until certain days known as open houses. Mr. Lebel did view the property on those particular dates of the open house, and he took a contractor with him to view this property. He was able to walk about the property, inspect the property, and determine if he was interested in making a bid on the day of the sale of the property. Mr. Lebel also testified in deposition as well at trial that he knew the next door neighbor of this property, and he had discovered that the next door neighbor was the quote caretaker of the property during the interim of the sale. So he contacted this individual, and on 2 different occasions outside of the open house dates went onto this property, viewed the property, and determining whether or not he was interested in viewing this property.
Counsel, what you're telling us and your opinion, your presentation is there was sufficient evidence, insufficient evidence to support a fraud verdict, that a jury had sufficient evidence to rule in your favor instead of otherwise.
That's correct. And that the trial court, in determining that a contract existed, made an incorrect finding of law, and that there was a contract between CWS Marketing and Mr. Lebel.
And what about the motion for new trial then? Was this issue presented to the trial judge for him to review, to determine or to weigh the evidence that the jury has ruled upon?
We moved the court for a directed verdict at the close of the proof, which is permitted under Tennessee Rule of Civil Procedure 50. I think the appellees argued that we had to make that again at the close of all the proof, and we, according to the rules, we do not. Rule 50 says we can make it at the close of opposing parties' proof and or the close of the proof in its entirety. We moved for a directed verdict, indicating to the court that there was no contract between CWS Marketing and Paul Lebel, and due to the fact that there was no contract between those parties, that the jury could not find any type of fraudulent concealment or reckless misrepresentation. The misrepresentation claims comes from the difference in which the appellees argue that there was 5 acres missing between what the actual property described as 35.5 plus or minus and or the actual property when Mr. Lebel closed on it, 30-some acres.
Okay, but you didn't file a motion for a new trial for the
We did not
judge
file a motion for
to
new trial.
weigh the
Didn't
evidence?
want a new trial. We didn't believe that a contract existed that permitted. We wanted the court to grant our motion for directed verdict that there was no contract between CWS Marketing and Paul Lebel. The contract was between the Internal Revenue Service and the Department of Treasury and Paul Lebel. The contract was never signed by CWS Marketing. There's not a signature line for CWS Marketing. CWS Marketing was not a party to this contract, and I think our precedent indicates clearly that to breach a contract, you have to be a party to the contract, and we are not a party to this contract. And there was insufficient evidence. The contract was permitted into proof, and there's just insufficient evidence that we were a party to this contract in any regards.
Okay, all right.
So Mr. Lebel, during his times of going to open house, he had been placed on notice that a facade, a bamboo ceiling, now I'm going to call it a ceiling, but the ceiling was underneath what we're going to call a concrete deck that was exposed outside, and this bamboo ceiling, this facade, had fallen at a certain point in time. And this, I'm going to call it like there were bevels, and these bamboo ceilings just laid within those. Up above it was concrete. And Mr. Lebel became aware that they had fallen because the individual that he had employed to allow him access to the property outside of the open house told him I had to pick that up and put it back up once upon a time. So he was aware of that. Mr. Lebel further became aware of that before closing, but after he had the winning bid, before he closed, he became aware of that. And there were some communications between Mr. Lebel and CWS Marketing that indicated, and the transcript will reflect this, that indicated he was on notice that this bamboo ceiling had fallen, this facade. That's the fraudulent concealment that they claim existed. Mr. Lebel chose, after becoming aware of that, to proceed to closing, and he closed, and he bought this piece of property. At trial, he testified that it cost him tens of thousands of dollars to replace this. The contractor that was employed indicated that there were several things that Mr. Lebel just wanted to do that was different. So we present to this honorable court that there was no contract between CWS Marketing and Mr. Lebel. As a matter of fact, in the contract for sale of government real property, that's the title of the contract. That's trial volume 8, exhibit number 4. Acknowledge that Paul Lebel and his wife, Christine Wu, as buyers, and CWS acting as agent of the government with respect to this sale of this government real property and on behalf of the Internal Revenue Service, open quote, seller. Signature lines, there's a witness to the signature of the buyer, Will Sliger, and Paul Lebel. The witness to the seller is James Bird, not employed by CWS, not an employee of CWS. And Internal Revenue Service signature line, Dennis Holenstein. So respectfully, we submit to this court that there was no contract between CWS Marketing and Paul Lebel. Due to the fact that there was no contract, there was no failure to perform on that contract, fraudulent and concealment, and that prior to the closing, in between the winning bid and the closing, Paul Lebel became aware of all these items that he's fussing about and chose to close on this property. The appraisal of 2016 when this property was sold listed the appraisal which CWS relied on in presenting to the IRS that this is 35.5 plus acres of property. The appraisal indicated it was 35.5 acres.
Well, but that wasn't the only information available to your client was as to the size?
Well, my client was CWS Marketing. They had their own appraisal done.
I understand.
They did not go and do research 10 or 15 years in the past or do any more research. They relied on the appraisal. CWS Marketing did.
Let me take you back, though. Is it your opinion that it's no problem for you that you didn't file a motion for a new trial and raise these issues?
I do not think so, Your Honor. I think if we look at the motion for new trial language in the rules, respectfully, Judge, subsection E, in which the appellee argues about, says, provided, however, that in all cases tried by a jury, no issue presented for review shall be predicated upon error in the admission or exclusion of evidence. We're not arguing that evidence was submitted improperly. Jury instruction granted, we're not arguing on jury instructions. Or refused. Misconduct of jurors, we're not arguing that. Parties or counsel, not arguing that. Or other action committed or occurring during the trial of the case. We're not arguing.
Well, aren't you arguing other actions that occurred during the case?
No, we're arguing that the court made a mistake in allowing the jury to determine that there was a breach of contract because no contract existed.
And you're saying that's not an action that occurred during the case? During the trial of the case?
An action that occurred? I don't know that I would.
No, I don't mean like a cause of action. I was using the language.
I would suggest respectfully, Judge, that based on the evidence that was submitted at trial, which was not opposed or objected to, gave the court the ability to grant our motion for directed verdict that there was no contract that existed because that contract came into evidence.
Yeah, I understand that's your position about the contract, but I mean, this court said for this court to review the sufficiency of the evidence on appeal, a motion for directed verdict must have been made at the conclusion of all of the proof and renewed in a post-judgment motion following the jury's verdict. Is that?
I read Rule 50.01, the first line, a motion for directed verdict may be made at the close of the evidence offered by an opposing party or at the close of the case.
Yeah, but that's just saying when you can make it.
That's correct.
But what about the language I just read you? Are you saying that that's not the law anymore?
Are you reading?
I'm reading out of a case. McLemore versus Elizabeth in medical.
I would not suggest that something is not the law anymore. What I'm suggesting is that our right of appeal does not require us to file a motion for new trial on the judge's refusal to grant a directed verdict because the judge made a determination wrongfully, with all due respect, that a contract existed.
All right, thank you. You have your time for rebuttal.
Thank you, Judge.
Here from the Appellate.
Good morning, Your Honors. Dylan Parker, the Hamlin County Bar, here on behalf of Paul Lebel. As has been discussed this morning, no post-trial motion was filed. Under Rule 3, it's clear, no issue presented for review shall be predicated upon any error. The error that appellant is arguing is, one, the judge erred by not granting his motion for a directed verdict. We've cited about a half dozen cases where this court has said, different panels, that issue is waived. The error of a judge in granting or not granting a motion for a directed verdict must be raised in a motion for a new trial. In addition, the appellant did not file a reply brief on this issue. On page 15 of our brief, we've cited about a half dozen cases, including the McLemore case. Quote, for this court to review the sufficiency of the evidence on appeal, a motion for a directed verdict must have been made at the conclusion of all proof and renewed in a post-judgment motion following the jury's verdict. Cortez versus Alutech, which is on the same page, quote, once appellants moved for a directed verdict at the close of all proof, it was incumbent upon them to renew their motion at the close of all proof as an initial step to preserving the issue for appeal. So in sum, we've got two reasons for waiver here. One, the motion for a directed verdict was not made at the close of all proof. Two, there was no motion for a new trial. Assuming the court finds that there was no waiver, we submit that the jury's verdict was submitted by material evidence, supported by material evidence. Opposing counsel has referred to the breach of contract cause of action, but that's not the only cause of action that we asserted. We also asserted a fraud cause of action and fraudulent concealment as to both issues. One, the opposing counsel referenced this bamboo ceiling falling, but that's not really the issue. The issue was what was hidden underneath the bamboo ceiling, and it was extensive water damage that required this entire wing of the house to be demolished. So what the jury found was that when this bamboo ceiling fell, that surely they must have discovered all the water damage there. The testimony at trial was that it was so water saturated that you could take a finger and push it directly through the wood. And there was mold additionally. And in addition, the evidence showed that the appellant received an invoice from a property manager that said, hey, we've got mold, we fixed it, to the best we can. They did nothing to investigate that. CWS's marketing manager said, when asked, what did you do after you received this invoice? He said nothing. He was asked if he asked for photographs of the mold. He said, I did not. A big part of the appellant's argument at trial was the as-is clause in the contract. As this court has said many times in the past, an as-is clause may be a shield for negligent misrepresentation, but when it rises to the level of fraud, which is what we alleged here, it is not a shield against a fraud claim. As to the fraud claim, defendants point to two elements. One, that the representation was not made either knowingly or recklessly. We argued at trial in terms of both the acreage issue and the water damage issue that it was made recklessly. The Tennessee Supreme Court's defined recklessly as, quote, aware of but consciously disregards a substantial and unjustifiable risk of such nature that the disregard constitutes gross deviation from the standard of care, end quote. As to the water damage, it showed that the defendant knew about it. It wasn't just reckless. They were told directly that that mold was present above this bamboo ceiling, and in response to that, they didn't disclose it to bidders. Instead, they decided they were just going to put the bamboo, clean off the bamboo ceiling, put it back up, not say anything about it. We submit that the jury got it right, and they found that that was fraud. As to the acreage issue, there was a brand new 4-lane highway being constructed directly beside this property. CWS's manager testified at trial he knew about that. And he was also given a plat from the Internal Revenue Service when they received this property that said 29.5 acres, and then in all caps, after state. When asked what he thought about that language, after state, he said that he didn't really pay attention to it at the time. So he has a plat that says it's 6 acres less than they ultimately advertised it for. He has an auctioneer hired by the defendant who says it's 29.5 acres. And then because a marketing employee with a defendant sent an email that said, quote, I think it's 35.5 acres instead of 29.5, that they just went with a larger number. Despite having this conflicting information, they just said, we're going to advertise it as 35.5. The plus or minus issue, so there are multiple advertisements for this property that appeared in local newspaper and in a realty magazine called Auction Zip, and it did not contain the plus or minus. The testimony at trial from my client was that he learned about this property through Auction Zip, and that it contained no plus or minus. Even on the flyer that the defendant created and handed out on the day of the auction, the main description of the property says it, quote, sits on 35.5 acres, end quote. Down towards the bottom, it says 35.5 plus or minus. So there's an older case from this court. It's called Del Forge versus McMurtry. It says, quote, addition of the words more or less will not deprive a purchaser of his remedy where the seller represented as fact and not by way of opinion that land contained a certain number of acres, end quote.
Didn't you have an expert also say that the plus or minus, there's a limit to that, and this exceeded the limit?
I don't recall right off the top of my head exactly what the expert said, but I believe that was the gist of his testimony. And Mr. Lebel, who's a commercial realtor, my client, testified that plus or minus to him means minor discrepancies. I believe the testimony was that typically after the point, there's 3 numbers after that, 29.353 or what have you, and that to him it means there might be some differences in the hundredths place, so to speak. Not a 6-acre discrepancy when we're talking about a 35-acre property. I believe my client's colorful quote was, that's like chopping off your leg and saying plus or minus.
Maybe that was the expert I was referring to.
Okay.
I remember there was some testimony that the plus or minus is not unlimited. There's a reasonableness factor in there.
Yes, Your Honor. So the second element of the fraud claim that the appellant takes issue with in their brief is the reasonable reliance prong. My client, again, who's a commercial realtor, testified that he's been to over 100 auctions, and where the property is advertised as a precise amount, that always the auction companies have conducted a survey, and that he relied on that past experience when he saw this flyer that said 35.5, no plus or minus, that's exactly how much the property was going to be. Second, he testified, and I believe Mr. Boland, opposing counsel, just said that there was very limited access to this property in the weeks prior to the auction. And my client testified that it would not have been feasible for him to hire a surveyor to go and survey the property because there wasn't enough time between the dates that the property was made available for inspection and the auction. As to the water damages, the reasonable reliance prong, in the contract that the defendant gave to my client, it defines seller as, in part, CWS marketing. Now, the real seller here, of course, was the IRS, but the contract that CWS marketing gave to the plaintiff said, quote, we have disclosed all known defects. My client testified at trial that he took them at their word, that they had disclosed all known defects, and more importantly, he couldn't have discovered this issue without physically taking the faux bamboo ceiling down and examining it himself. I believe he testified that he wasn't going to be allowed to go in there with a sawzall and look behind walls and ceilings to find this problem.
So let me assume something for this question. Assume that the trial court, that it was error for the trial court to let the breach of contract go to the jury. Assume that.
Okay.
And assume that it wasn't waived, anything about it. Is that a problem for you?
I don't think so.
Why not?
Because, so there's 2 defects we talk about that are both covered under the fraud and fraudulent concealment claim. So the fraudulent concealment claim only goes to the water damage. They didn't conceal the acreage damage or the acreage issue. So even assuming that there was error on the breach of contract, the water damage issue is covered by the fraudulent concealment. The acreage issue is covered by the fraud claim because they made a representation in the advertisement they created that said it was 35.5 acres. That was reckless because they had conflicting information and didn't investigate it. On the fraudulent concealment claim, defendant says there's 3 elements we didn't satisfy. One, that it was not material. And I think a little bit disingenuously, the appellant says that the problem was the fallen ceiling, which was not the problem at all. It was what was hidden above the ceiling. So while, a faux ceiling falling, a tray ceiling falling might not be that material, the fact that it's hiding extensive water damage that requires demolition of a wing of a house, of course, is material. Second, they claim that they didn't have a duty to disclose. As agent and marketer of this property, they were the only ones in a position to disclose anything. The IRS, the testimony at trial, had nothing to do with the sale besides handing it off to CWS to sell it. CWS is the only one who knew about these issues and did not disclose. And every party to a contract, whether there was a contract here is debatable, but as an agent and marketer, I think they had a duty to bidders to disclose the water damage they found and to, well, we're on the fraudulent concealment claim, so just the water damage is at issue. So they were told about it and didn't disclose it. We say that's fraudulent concealment. Third prong is whether they hid it. And, you know, the testimony was that it fell, it was discovered, they put it back up, didn't disclose it. We submit that's hiding the issue.
What about your client? Did your client have an obligation to inspect?
Absolutely, and he did inspect. This particular issue, the water damage, was not reasonably discoverable by anyone without physically removing the ceiling.
Where of the water with the bamboo, though?
He was aware that the bamboo, so just, I think there was some confusion during opposing counsel's argument. So the way that it went, bamboo ceiling falls first time, it's put back up, auction happens, my client knows nothing about the bamboo ceiling falling. After the auction, but before closing, it falls again. He discovers this, calls, well, I'm not sure exactly what the testimony was on how it was discovered. He becomes aware of it before closing happens, and they tell him, oh, look, this happened before the auction, we just put it back up, we think it's an improper installation issue. He says, just leave it down then, and I'll put up a different ceiling. So he was never physically there to inspect, to find the problem before closing. Certainly not before the auction. He didn't have any idea about this before the auction. And the last issue we raise in our brief is about attorney's fees on appeal for a frivolous appeal. Pursuant to TCA 27-1-122, this court, of course, is empowered to award appellate attorney's fees in appropriate circumstances. We've cited 3 cases from various panels of this court since the 90s, where every time that frivolous appeal damages were requested, where a motion for new trial was not filed, it was granted. I looked, could not find a single case where frivolous appeal damages were requested, where a motion for new trial had not been filed, and it was not granted. So we submit that there's precedent for it, and it's important to remind litigants that you've got to do this to preserve issues for appeal, and I think frivolous appeal damages would accomplish that goal. If there's no other questions,
I hear none. Thank you.
thank you, Your
Hear
Honor.
from the appellant in rebuttal.
Just briefly, Your Honors. The language in Rule 50.01 clearly would be in conflict with the cases that are cited. Tennessee Rule of Civil Procedure 50.01 was amended in 2022. I don't know what particular language it was amended to, but it appears that the McLemore case that Your Honor cites also uses the statement that they shall make a motion for directed verdict at the close of proof. That the McLemore, that's in quotes in the McLemore v. Elizabethan case. However, Rule 50.01 does not say that. And they cite to Rule 50.01 in the McLemore case. Rule 50.01 says offered by at the close of the evidence offered by an opposing party or at the close of all proof. So there's some conflict between the McLemore case citing Rule 50.01 and what Rule 50.01 indicates. Because the McLemore case in and of itself, when arguing that, Your Honor, please, when saying that, says that they must, and I quote, we stated that the question of whether evidence is sufficient to support a jury verdict is tested by a motion for directed verdict, and in order for the trial court to consider the sufficiency of evidence, the moving party must have made a motion for directed verdict at the conclusion of all the proof, citing Tennessee Rule Civil Procedure 50.01. So there's conflict there, clearly, between what 50.01 says and what McLemore says it says, unless it's citing to an old version of that rule that said that they must be made, and now the rules have been changed to or. I don't have that answer before the court today. I'm happy to offer supplement if that's in fact the case. But I do want to highlight what the Honorable Judge McClarty asked about. Mr. Lebel had unrestricted access to this property because he employed individuals to allow him on the property when he knew he wasn't supposed to be on the property. Even after he won the bid and prior to closing, he was aware that this bamboo facade roof had failed. And he went on the property once again, because when he sent the letter or the email to CWS Marketing, their first thing is, what in the world are you doing on the property? Because they must abide by the rules set forth by the Department of Treasury and the IRS that nobody's supposed to be on that property. It's an unfair advantage. And they call him out on that. And he's on that property. He took a contractor with him. He chose to close on that property. He was well aware that they were cutting a road in and that there may be some deterioration of some acreage. He was well aware of that, had all the ability to do his own due diligence and go to the courthouse. And I close, and I'm asking this court to set aside the verdict that there was no contract that existed between CWS Marketing, there was no duty to perform, and there was no damages related. Thank you.
Of course, thanks to counsel for both sides. Appreciate your arguments and your briefs.